Good afternoon. My name's Neil Brown, and I'm terribly sorry. I'm afraid I'm a lawyer. I've been asked to come and give you a quick update on the Investigatory Powers Act. I think it's come to UKNOF a number of times before. What I've been asked to talk about is sort of a practical look at it. I have a tech telecoms background. I've worked in this area for about 12 years now in the sort of legal advice to telecoms operators and in the investigatory powers space. So hopefully this can be made pretty practical for you. Three things I will try and cover. The first, where are we now? Where is the Act at the moment? Where are we in terms of its implementation? And a quick overview of it. The second bit will be the meat of the session, looking at what practically might you want to do to try and comply with it if you're served with one of the warrants or notices or orders that comes under it. If you were hoping that this was a session of, I want to avoid compliance as much as possible, what do I do? This won't be the one for you, I'm afraid. This is more geared at, if you get an order and you want to know what to do about it, it will give you a framework to think about those things. Lastly, I was asked to talk about your policies. We'll cover most of that in the second bit, so instead I'll talk a little bit about disclosures and talking to people about notices and warrants that you've received. But if we start off with where we are now, the Investigatory Powers Act is law. It's on the statute books. It was passed in November 2016. But it is far from fully in force. I'll talk a little bit about that. In terms of the Act itself, I believe someone took you through this at a previous UKNOF. So very quickly, it is made up of a number of different parts, 10 schedules sitting behind it, and about 300 pages in total. So nice and easy to digest. Starts off talking about the privacy controls, what safeguards there are in place to protect the privacy of the people who may be subject to the various orders under it. It then sets out on a part-by-part basis the different powers that are available. Goes from interception, obtaining communications data, Part 4, retaining comms data, Part 5, equipment interference, I'll come on to that, Part 6 is the bulk powers, 7 bulk personal data sets, and then it moves into the oversight, the miscellaneous bits. Always read the miscellaneous bits, that's where the interesting stuff is. The miscellaneous bits right at the end, and then 10 schedules worth of bits that are changing. That's what it is. As I say, it's not all in force at the moment. At the moment, all we've got is a basic data retention framework, replacing Data Retention Investigatory Powers Act that fell away a year or so ago. Bit about payments, you'll be pleased to hear. And an oversight body setting up the new Investigatory Powers Commissioner, setting up the office that will sit under him. The rest is yet to come. Timescale seems to be slipping. Some stuff this year, perhaps not everything in force until next year. The Act is in force, but it looks like there are going to be amendments to it before the certain bits even come into effect. So rules around communications data. Some of you may be aware there have been some quite high-profile challenges to retaining communications data. And the government so far has said, no, we don't need independent authorisation of that. We can authorise within the police force or the requesting agency. The Home Office has a consultation that's open for another 2 days that says, actually, perhaps we need independent authorisation. So won't affect you as operators because this happens in the background before you'd see anything. But just to say, the law as written at the moment looks likely to change before it will come into force. So the framework today is a pretty patchwork of bits and pieces. Interception is under Regulation of Investigatory Powers Act, RIPA, and some bits under the Wireless Telegraphy Act. Obtaining communications data, well, RIPA is the main authority for that, but there are hundreds of other pieces of legislation, the Enterprise Act, Social Security legislation, Salmon and Freshwater Fisheries Act, all these pieces of legislation dealing with salmon and trout tickling and various other serious crimes against the nation, have powers under them that would allow the acquisition of comms data. Retention of communications data, that's one of the bits that is now covered by the Investigatory Powers Act. Removing electronic protection, asking you to strip a password off an employee's laptop or something or provide information across, that still sits under RIPA. National security, the very old Telecoms Act legislation from 1984, and equipment interference, a mixture of bits and pieces, but particularly the Police Act and the Intelligence Services Act. What it will look like once the IPA comes into full effect, far more of it falls under the IPA. Interception Part 2, CD acquisition, comms data acquisition Part 3, and a far more limited set of other legislation. Retaining under the Investigatory Powers Act. Removal of electronic protection, that will stay under RIPA. National security, that gets folded into the Investigatory Powers Act at Part 9. And equipment interference, Part 5 of the Investigatory Powers Act, and some other bits as well. Not a complete change there. So we'll move from a patchwork framework into something that's a little more unified, but not wholly unified, under the Investigatory Powers Act. For those for whom this area isn't particularly familiar, interception, the real-time acquisition of the content of a communication and associated secondary data. So the content, the what is being said, or the what's being transmitted, along with the metadata about it. Data retention, holding on to communications data for subsequent access by law enforcement or intelligence agencies. Generally, this is going beyond what you need for your own business systems, because otherwise you simply have that. That would just be acquired under acquisition powers. This is a specific order telling you, we want you to retain, or we compel you to retain the following types of data for the following periods. The flip side of retention is the communications data, disclosure if you're an operator, acquisition if you're an agency, the getting the data from the operator. Equipment interference, a reasonably new term that seems to have come up, which most people are equating to hacking. It's a poor shorthand, in my view. Equipment interference is effectively doing anything with a communication system for the purpose of obtaining communications data. So it doesn't cover hacking to take a system down, unless in doing so that's to acquire communications data in some way, and it's potentially broader than what you'd consider to be hacking in a traditional sense. There are a couple of new notices in there that I'll talk about a little later, but so you can contextualise them. A technical capability notice is a notice that compels you to put stuff in place so that you can satisfy a warrant or a notice that's served on you. It's generally something like an infrastructure building obligation to say you're likely to receive a number of interception warrants, build this infrastructure so that you can ensure you can do interception. A national security notice is a notice that can compel you to do something that you can't otherwise be compelled to do under the Act. So you can't use a national security notice to acquire comms data or to do interception or equipment interference. You can't use it to compel someone to build capability to do one of those things. It is used for other purposes, and those purposes are generally pretty opaque. The example that's most often given is to say that an agency wants an operator to build a particularly special communication service for them. They may use a national security notice to help encourage the development of that. So it's not necessarily a surveillance power. It may be used in a broader sense to support agency work. So we've looked at what's in the Act, we've looked at what's enforced now and what the landscape will be when it's in, and some of the definitions. So let's talk about handling demands. And we start off with this idea that not everything that you get sent by law enforcement is mandatory. Sometimes you get something that may look quite mandatory, but actually it's a request. It's genuinely asking you, we can't compel you to do this, but we'd really quite like it. Would you please consider doing so? Even if it looks a bit mandatory. And the example I see most often is a request under the Data Protection Act. You may have come across them. A notice comes in from the police, typically under Section 29(3), saying, we think you probably have something that will be helpful to us. It contains personal data, so would you please disclose it to us? If you don't, it will be likely to prejudice the investigation or detection of crime. That's a voluntary notice. You don't have to comply with it as a matter of law. And so when you get these things, check them carefully. See what legislation it falls under. Have a look at it, see whether it's a power or whether it is simply something that they're asking for. You've got broader principles to bear in mind. If you were to intentionally refuse when you could legally comply, you may commit an offence of obstruction. But take a look at it, what's coming through, and assess whether you're compelled to do something or whether it's simply a request to do something. And you can always go back and ask the requesting person, I'm not quite clear, can you tell me, are you compelling me to do this, or are you asking me to do this? If you've decided it's not a voluntary notice, then if it's actually one of the mandatory ones, what is it? Different notices will demand slightly different responses, and we can split them into two types: the strategic type of notice, the technical capability notice, or the sort of case-by-case notice, the acquisition warrant, the more tactical notices. So the strategic notices, if you don't have one already, the Home Office's view is you are unlikely to get one. They're not going to say never, but you're unlikely to get one. And if you have one already, you probably know the kind of things that you're going to expect. And they look pretty similar under the Investigatory Powers Act, not identical, but pretty similar, so you'd probably be familiar with them. You will get a prior consultation before someone comes to serve a strategic notice on you, so you'll get some forewarning, and at that point, and okay, I'm biased, having a chat with a lawyer at that point is probably a sensible thing if you're being asked to build a strategic capability for some sort of surveillance framework. But you will get notified beforehand. People will ask to come and have a chat with you and work out what sort of thing might be needed given your particular infrastructure, the particular service that you're offering. So relatively few of these, and if you haven't got one already, it looks likely from what the Home Office has said and the codes of practice that you probably won't get one of these. More likely is one of the tactical notices. So, for example, a warrant to compel you to do interception, a notice compelling you to hand over communications data, or a warrant for equipment interference. You might get prior warning, more usually in the case of interception, because someone will want to check that the target's actually interceptable on your network. You'll probably get a warning of equipment interference for very similar reasons, probably not for communications data acquisition. You're more likely to just get an email through saying, here's the attached authorization, here's the notice, please can you disclose us the data that's enclosed, the data that's set out in the notice. So probably no warning in that case. The other ones you're more likely to hear through. So first of all, is it a voluntary notice, or is it a mandatory thing that you have to comply with? And if you've decided it's mandatory, step through a simple process to work out how to respond to it. Verify sender. So the last two presentations have looked quite a bit at the idea of fraud and of communications not necessarily being what they appear to be. Anyone can send a notice that looks like a notice under the Data Protection Act. Anyone can send something that looks to be a demand from law enforcement. So your first step, is it genuinely the case? Now, if you deal with these things regularly, you will have points of contact within police forces to be able to go back to them and say, okay, it hasn't come from someone I know, I will be able to go and check it. If you haven't, you're in a pretty tough situation, if I'm perfectly honest, and I don't have a satisfactory answer for it. Other than being able to go back to the person in question and say, well, can you please get your telecommunications single point of contact to get in touch? Or trying to find a phone number that isn't in the email in question for the force, and ringing up and saying, well, can I please speak to this person? They have apparently sent me a notice, and trying to validate it by a secondary channel. I don't have any particularly good advice to give you. But first of all, try and work out whether it's a genuine request or someone trying to blag information from you. I feel this is part of the process that I think could certainly be improved. And if you've validated that it is a genuine, that the sender is entitled to send it to you, they are who they say they are, validate the notice itself. What legislation is it coming under? Is it really a mandate? Go and have a look. Does that legislation let them compel you to do what it is that they're asking to do? And although the Investigatory Powers Act is quite big, when you're given a section reference, going into it and seeing, well, does it apply, that's a bit more of a straightforward thing to do. What is it requiring you to do? Is that something that you can be legally compelled to do? Can it even be served on you in the first place? The definition of telecoms operator under the Act is really broad. It covers public providers, private providers, providers of all sorts of services. So there's probably a good chance it does apply to you. But if you're providing certainly anything a little unusual, take a look, see whether you fall in the definition of telecommunications operator. What you can't do is try and look behind the notice. Try and work out whether what they're asking is necessary and proportionate. That's a decision that's taken before the notice is imposed on you, and at that point your obligation is to comply with it. Now, if you were particularly bloody-minded and you wanted to go down a route of litigation, judicial review, challenge before courts, that kind of thing, yes, you may attempt to look into the necessity and proportionality. But generally, you will not get any information like that. It will simply say, here's your notice, deal with it. It's a mandate, so please carry on. So you've verified the sender, and you've validated the notice. It is something that can be served on you, and you feel that you are compelled to do it. Well, can you fulfil it? Can you do what it's asking you to do? If you're served with a notice that's valid, you have a statutory duty to assist. You are bound to assist. In most cases, there's the potential for an injunction if you don't assist. In some cases, in the case of interception and I believe equipment interference as well, it is a criminal offence if you do not assist with a valid warrant served on you. So clear incentive, if you can validate and verify it, to do what it says. If you have a technical capability notice, that will have compelled you to build infrastructure to ensure that you can comply with a warrant. If you don't, which is the most likely situation, it's not an unlimited duty. You're required only to do what is reasonably practicable, which is a beautiful legal turn of phrase. You're only required to do what you reasonably can do to satisfy it, and there's no one thing there that will meet that test. It will depend on what's being asked, your own systems, your own infrastructure, what can you do to actually help. If you can't, or you're not sure you can do anything, go back to the person who's asking for it and have that conversation with them. If you want to be helpful, you can explain what you can't do, but potentially what you could do that would still fall within the warrant. But if there's something you can't do and it's not reasonably practicable for you to do it, tell them. People thought this might be a good slide. Ask about cost recovery. I don't know how many people do this when they get served with something, but the Home Office fully appreciates that it takes time away from your business to deal with this kind of thing. There is a cost recovery framework there, and the draft code of practice, it's only a draft at the moment, but assuming it stays in its current form, the draft code of practice for communications data specifically calls out that, yes, operators are entitled to go and ask for recovery of costs associated with the assistance that they're giving. You're not going to get an unlimited sum of money for it, but if you were to put in a request for sort of payment for your reasonable costs associated, that would seem a perfectly realistic thing to do. You can't not assist if they refuse to pay you. You've got a statutory duty to assist, but you can certainly ask, and that is a reasonable thing to do. So you've got your notice, it's from who they say they are, you validated it, you can fulfil it reasonably, you've asked, and with a bit of luck, they've agreed to pay your invoice for doing it. So you get on and do it. Keep records of what you've done. You're required to keep two different sets of records. The first of all is some records about the request itself, and that's fundamentally who asked for it, their internal reference for the request, when were you told about it, and when did you disclose it. So some sort of almost metadata records about what you've been asked to do. On top of that, you're asked to retain sufficient records to ensure that you can confirm the exact communications data that have been disclosed. For interception, slightly different, but focusing on the most common notices, the communications data ones. A record to confirm the exact communications data that have been disclosed. So that could be keeping a gold copy of the data themselves. It could be trying to come up with a record and then hashing it and then being able to verify if you're given a copy of the data in future, show that the hashes match, so yes, it's the same data. My experience, most forces aren't in a position to supply the original data back to you in a format where you could hash it and then compare hashes. So keeping the original data for a period seems to be the more sensible approach there. And it talks about court, and yet there is a step 6, which is it could possibly end up with you going to court. More likely, you'll be asked to write a witness statement setting out this is what you've done, this is what you've handed over. They're still pretty rare. Scottish police tend to ask for statements quite a lot. They don't tend to like writing their own statements, in my experience. English and Welsh forces tend to write their own statements. They tend to self-statement, but occasionally you might get a request to write a witness statement. Normal rules apply. Don't say anything that you wouldn't be prepared to stand up to in a test in court. Don't write about stuff that's outside your own knowledge. If you went to someone else to get them to do this, say that that's what the case is. If they then want to go and get a witness statement from someone else, fine, let that happen. But only write about stuff that's in your own knowledge. Very, very rarely you may be asked to go to court to sort of speak to your witness statement. Over all the years I've done it, I can only think of this as come up a handful of times, so I'd consider that as an extreme and probably unlikely situation. But that would be, to my mind, the most sensible framework. Is it a voluntary demand? Is it a mandatory demand? If it's mandatory, run through the simple 6-step process, and that will hopefully get you out the other end, having complied with your legal obligations, hopefully had some reimbursement for the costs that you've incurred in doing so, and hopefully you don't have to give a witness statement or go to the trouble of going to court to give evidence on it. The last part of what I wanted to talk about was setting your own policy, but since that mostly seemed to be setting your own policy, instead I want to talk about disclosures. Warrant canaries have come up a number of times, whether you can disclose a notice, whether you should write a transparency report, that kind of thing. And very recently, this is the bit that actually looks a little legally. There is a court case reference there. It's a European Court of Justice of the European Union reference in a case relating to data retention. And the Court of Justice said in this case that notifying people that their data have been retained and that their data have been acquired by law enforcement is necessary. The police force or the agency requesting the data must notify the persons affected as soon as doing so wouldn't jeopardise the investigation. And the reason they say that is because, you know, people who are affected by it need to know that things have happened so that they're able to attain a remedy if their rights have been infringed. Now, the Home Office takes a slightly different view that this isn't necessary. The Home Office's view is that our legislation affords sufficient safeguards that you don't need to give notification. So while that's what the European Court has set out is necessary, there's a bit of an however to it. And the however is it's probably a criminal offence. Under the Investigatory Powers Act, there are a number of prohibitions on disclosure of notices or warrants. So for an interception warrant, I believe, again, under an equipment interference warrant as well, it will be an offence to disclose the existence, let alone the content, of the warrant, unless it's one of the accepted disclosures. Do not get excited. The accepted disclosures are really narrow, and it's basically stuff you need to do to get it done, or stuff you need to do to get legal advice as to whether you should do the stuff you need to do to get it done. So no particular basis for talking publicly about an interception or an EI warrant. For communications data acquisition, it's still a criminal offence unless you have a reasonable excuse. Reasonable excuses, to my mind, don't comprise telling everyone about the communications data acquisition notice. Again, it's more likely to be for seeking legal advice or for talking to a regulator in the event of a problem. Disclosing a retention notice, not actually a criminal offence, it seems, under the Investigatory Powers Act, but if someone got wind that you were intending to do so, may possibly obtain an injunction stopping you from doing that. Same with technical capability notices and national security notices, enforcement via an injunction to stop you from doing so. The ones that you think you can disclose, you'd want to check whether from an Official Secrets Act perspective you could disclose it anyway. It may be unfortunate if you disclosed it. Noting I have 2 minutes to go, warrant canaries, they're a bad idea. So what I've covered so far, where are we now? It's in, but it's still coming, and it looks like it's going to change before it actually hits us, but coming over the next year and a bit. Handling demands, voluntary, mandatory, 6-step process, validate, verify, see if you can do it, get your money back, hope you don't need to go to court, and think really carefully before you get involved in disclosures. You are very likely to trip up unless you're particularly careful.
Okay, thanks, Neil.
Thank you.